Good morning, and thank you for joining me on the Path to Liberty. I'm Michael Bolden with the 10th Amendment Center, and this is the Fast Friday edition of the show for July 28th, 2023. And today, following up on a bunch of great feedback, positive feedback from people who liked Wednesday's show covering some general warnings from the Anti-Federalist writer Brutus. A lot of people want to hear more on the Anti-Federalist, and I've been way overdue on doing this, so I'm finally getting back on track after almost 7 months, maybe almost 8 months off, covering the great Anti-Federalist speeches of Patrick Henry at the Virginia Ratifying Convention in the summer of 1788. And first a quick recap on his first series of speeches. And there's a consistent theme where he was warning against too much power. He had questions about the language of we the people versus we the states. He said the choice would ultimately be liberty versus empire. He warned against giving up rights due to fear. And he railed against the idea of implied powers versus expressly delegated and reserved powers. Now, if you want to find all of those, there's a section over at the show homepage, 10thamendmentcenter.com/path to liberty. If you scroll down, there's various different categories where you can find different episodes on a category by category basis. I have to do some updates on most of those, but the Patrick Henry ones are up to date. You'll see category Patrick Henry's Anti-Federalist speeches over at 10thamendmentcenter.com/path to liberty. That's also where you're going to find the blog post for this episode, which I'll publish in a couple hours after this show is done. And now let's move forward to his next series of speeches. We can call them, they're not really numbered, but that's kind of what I've been doing in this series. We can call them numbers 8 through 10 on June 18, June 19, and June 20th of 1788. And here from T.J. Martinell, he writes, under the Constitution, the Senate is delegated the power to ratify all treaties that the executive branch intends to make with other countries. For the founding generation, this represented a significant shift in treaty-making authority compared to the Articles of Confederation, which required 9 of the 13 states or 2/3 majority. So basically what you're saying is you're going to have instead of having the states individually approve this, and this was a very pure federalism type of approach, now you're just saying a certain number of the Senate is gonna approve that. Now, Patrick Henry, TJ writes, pushed back against this power at the Virginia Ratifying Convention, warning that it would undermine state sovereignty and potentially lead to treaties that violated individual rights. He warned that in combination with the Supremacy Clause, over and over, we're going to hear that today, in combination with the Supremacy Clause, they were going to come up with ways to say, well, federal law is supreme, this treaty power is supreme, we're going to be able to do this, it doesn't matter what everybody else thinks your reserved powers or your individual rights are. Here from his speech, he said, I say again that if you consent to this power, you depend on the justice and equity of those in power. And that was a big theme for Patrick Henry as well. You shouldn't have to rely on the people in power to be good people in order to be able to protect your liberty, because as soon as you do that, well, and he said this elsewhere, when you rely on people being good men, well, your liberty is going to be lost every single time. He said, we may be told that we shall find ample refuge in the law of nations. So some people were saying, well, you're worrying about the treating power, but there's this law of nations. And he said, when you yourselves have your necks so low that the president may dispose of your rights as he pleases, the law of nations cannot be applied to relieve you. In other words, almost nothing can be applied to relieve you of attacks from centralized power. He said, suppose you be arraigned as offenders and violators of a treaty made by this government. Will you have that fair trial which offenders are entitled to in your own government? Will you plead a right to the trial by jury? You will have no right to appeal to your own constitution. Maybe we can think about how that applies with things that are already on the books and maybe some things that are being proposed via treaty going forward. And we shouldn't be surprised to see this get far worse. Back to TJ, he said on June 19th, Henry continued his critique of the Constitution's treaty-making authority, arguing that it could permit agreements that infringe on both state powers, reserve powers, and the rights of their respective citizens, residents. Here he is. Suppose the state right to territory be preserved. I ask and demand, how do the rights of persons stand when they have power to make any treaty And that treaty is paramount to constitutions, laws, and everything. When a person shall be treated in the most horrid manner and most cruelly and inhumanely tortured. So he's talking about treaties that authorize torture. Very interesting. Will the security of territorial rights grant him redress? Warnings. Maybe some people thought it was hyperbole because, of course, they were saying, well, this is not how the treaty power works. But he warned, just like so many of the other anti-federalists, even if you can tell us what the original legal meaning is, people with power are going to use it in ways that they want to use it. And that, I think, is underlying a lot of Patrick Henry's warnings, just like with Brutus, Cato, and so many of the others. Henry continues, if the Constitution be paramount, and this is again to the Supremacy Clause, just a hint at that, how are the constitutions and the laws of the states to stand? Their operation will be totally controlled by it. For it is paramount to everything. Unless you can show some guard against it, the right of persons are exposed as it stands now. And even though the Supremacy Clause says, as long as it's pursuant to the Constitution, it's supreme, Patrick Henry warned that they would read it far more expansively than that. And he may be wrong in the fact that legally, that's what they were trying to do. And I'm not sure he was even really making that point throughout these speeches. He's just saying this is what's going to happen in practice. And I think with that, he pretty much nailed it, that an abuse of the Supremacy Clause is how this was going to all play out. Now, he continued that Supremacy Clause warning the next day on June 20th when he started getting into jury trials and the power of the judiciary. And here from T.J. Martinell again, during the convention on June 20th, 1789, it's 1788, we got to make an edit on that, Patrick Henry warned that the power bestowed to the Supreme Court would undermine the right to trial by jury. Here he is again. I have already expressed painful sensations at the surrender, not TJ, this is, TJ's awesome, but this is Patrick Henry, right at the beginning of his June 20th speech. And again, I'm going to link to all these in the show notes. When I publish that blog post for this episode, you'll first see like the audio player for the podcast, and then you're going to see an embedded video, and then you scroll down, you're going to see all these different other platforms we're on. Of course, we live stream on the mainstream ones like YouTube and Facebook and Twitter, and we also live stream over at places like rumble.com and odyssey.com. We're growing over there, and I really appreciate people following us on these other platforms as well. But we do also archive the video as many places as possible, including sovereign.com, a Brighteon, and BitChute, and we have the audio-only podcast edition pretty much everywhere. But below that, if you keep scrolling, it's not too much scrolling, so you'll be able to find a show link section where I'm linking to all these speeches, articles, and other episodes that I'm mentioning in this episode. So here from Patrick Henry, June 20th, I have already expressed painful sensations at the surrender of our great rights, and I am again driven to mournful recollection. The purse is gone. The sword is gone. And here's the only thing of any importance, which is to remain with us. He goes further. He said, so small are the barriers against the encroachments and usurpations of Congress that when I see this last barrier, this trial by jury, the independency of the judges impaired, and he's talking about the barrier of the state courts to protect the judiciary and the state level to protect against federal encroachments as well. But he's saying, well, the state judiciary also has to be, in essence, basically by having the supreme opinion of the Supreme Court's opinions, he's basically saying they're acting as federal judges as well. And then you can't serve two masters, and they're going to end up being basically on the side of the central government. And that's basically what he's getting to here. He said, I am persuaded I see the prostration of all of our rights. In what a situation will your judges be in when they are sworn to preserve he's going to do much better than I did in explaining this. When they are sworn to preserve the Constitution of the state and of the general government, if there be a concurrent dispute between them, which will prevail? They cannot serve two masters struggling for the same object. Going further, he said, nothing can be more clear and incontestable that this will in its operation destroy the trial by jury. And here's how he explains why. And this one I don't know if really resonates with me, but maybe it's something to think about. The verdict of an impartial jury will be reversed by judges unacquainted with the circumstances. And I'm not sure if he really nailed that one, we'll say, but he certainly had a broader warning a little further that makes some pretty good sense. He said, poor people do not understand. I think we can apply this to a lot of what the Anti-Federalists were talking about when it came to issues with the Constitution. A lot of the issues were that some of the phrases were very detailed legal terms, like necessary and proper. That means, in legal terms, the legal doctrine of principles and incidents. And I know most people have never even heard of this. Patrick Henry was aware of what it was. Patrick Henry understood what they were trying to say the general welfare clause meant. Even some of the other anti-federalists were saying, well, Mr. Wilson may tell us it means this. Mr. Hamilton may tell us it means this. But how is it going to play out with someone with power? What are they going to read it to be? People with power will always try to read any kind of ambiguities into expanding their own power. Why give them the opening? And that's what he's kind of getting at here as well. He said, poor people do not understand technical terms. Their rights ought to be secured in language of which they know the meaning. As they do not know the meaning of such terms, they may be injured with impunity. If they dare oppose the hands of tyrannical power, you will see what has been practiced elsewhere. In other words, just look at how other governments have treated their people, and if you give these people too much power, the result's going to be kind of the same, bad. They may be tried by the most partial jurors, by their most implacable enemies, and be sentenced and put to death with all the forms of a fair trial. Here again from T.J. Martinell, Henry also believed that giving the federal courts jurisdiction over disputes between the states and Congress would make it impossible for the court to be independent. We've often referenced the fact that going to federal courts to dispute issues of federal power under the Constitution really doesn't make a lot of sense, because in essence what you're doing is you're asking the federal government to police itself, relying on part of the federal government to limit the power of the federal government, asking the federal government to stop doing things that the federal government wasn't supposed to be doing in the first place. It's basically like my friend Tom Woods has said for many years. It's like if you're in a divorce proceeding and you want the person to adjudicate it, and you've got your mother-in-law on your side, or your mother is on your side, not your mother. Your mother-in-law is the opponent. If you have someone on your team, you're probably going to be winning in most situations. And now, Patrick Henry didn't use that same analogy, but he thought it was very dangerous to have to rely on part of the federal government to limit the federal government itself. So again, he believed that giving the court jurisdiction over disputes between the states and Congress would make it impossible for the court to be independent, since the court itself would be part of the same federal government. And a lot of people seem to forget that today. They always want to run to the federal courts to protect us, when the federal courts are part of the problem because they're part of the largest government and largest empire in history. And here's how Henry put it again. Tip of the hat to the Supremacy Clause. He said, the laws of Congress being paramount to those of the states and to their constitutions also, whenever they come in competition, the judges must decide the law in favor of the former. This, instead of relieving or aiding me, deprives me of my only comfort, the independency of the judges. And this is one I think he really, really nailed, because if you look at how the federal court system is operated when it comes to constitutional issues, they're far closer to a rubber stamp than a protector of the original legal meaning of the Constitution, a rubber stamp for federal power. A vast majority of what comes before the federal courts, at least in the past 100 years, I mean, you may like a handful of maybe small victories in recent years, but in comparison, if you zoom out and you look at the big picture, it's barely scratching the surface. And even in many of the so-called good ones, they're still reinforcing a lot of the same bad precedents. So this is not a system of protecting the Constitution and liberty. Again, if you have to go to part of the federal government to limit the federal government, this relieves you of your only comfort, the independency of the judges. And for Henry, ultimately, this all gets down to too much power. He repeatedly warned against consolidation or centralization of power throughout his speeches. For example, here he said, dangers are to be apprehended in whatever manner we proceed. but those of a consolidation are the most destructive. And one more time, he said consolidation. He said, the more and more I think about this, consolidation must end in the destruction of our liberties. Well, I hope you guys found this quick take interesting. I hope it was educational. I hope you enjoyed it. I hope it encourages you to read, listen, and learn more on your own time. Of course, I'm going to have all this stuff in the show notes. At very least, you should read through TJ Martinell's overview articles, which I will link to as well, 10thamendmentcenter.com/path to liberty. And if you want to help us reach and teach more people with this kind of information and with how to also defend the Constitution and liberty when the government refuses to do so, which is constantly, and you got a couple of bucks of dirty government fiat sitting around, our membership program starts out at just $2 a month over at 10thamendmentcenter.com/members. I really appreciate you watching the show. I hope you have an awesome weekend, and I hope to see you next week here on the Path to Liberty.